Hello, everyone, and welcome back to the Rebuttal Podcast, where we break down case law, comedy, and of course, chaos in the legal field. I am your host, Reb Maisel, and we are going to cover two cases today. The first one is short and sweet and to the point because it's hilarious, and the latter one is a bit longer because it covers a saga related to buttocks being used as a potentially very deadly weapon. I know, this is a great episode, y'all. Let's get into it. This first one requires that you have a little bit of context on obscenity laws. Now, the U.S. Supreme Court's obscenity standard, right? Defining something as obscene, which can subject it to certain limitations and actually not allow it to be protected by the First Amendment. There is a reason why we do not have porn billboards up showing photos and images of naked people engaging in sex acts around the public, right? You would think, well, isn't that First Amendment free speech? Well, yes, it is. However, certain categories of speech are defined as those which have limited protections that are able to be censored to a certain extent, or at least be regulated more so than me just yelling on the street would be, okay? An example of that is defamation. Defamation falls into another category of speech that we are permitted to regulate, limit. People can sue for something that you say because it falls under a category, you're defaming someone, you're slandering someone, that would mean you don't have as many protections under the First Amendment. So, with all that being said, the U.S. Supreme Court's obscenity standard, figuring out what's obscene and what isn't, what could subject something to more regulations and what couldn't, is the Miller test, which was established in Miller versus California in 1973, which defines obscene material as lacking serious literary, artistic, political, or scientific value, and appealing to prurient interest in a patently offensive way, judged by contemporary community standards, with the work taken as a whole. For expression to be declared obscene and thus unprotected by the First Amendment, it must meet all three prongs of a specific obscenity test. Now, obscenity brings up the famous quote by United States Supreme Court Justice Potter Stewart in 1964, who used the phrase, "I know it when I see it," to describe his threshold test for obscenity in Jacobellis versus Ohio, explaining why the material at issue in the case was not obscene under the Roth test, formerly used, but now it's the Miller test, and therefore was protected speech that could not be censored. He wrote, quote, "I shall not today attempt further to define the kinds of material I understand to be embraced within that shorthand description, quote, hardcore pornography, and perhaps I could never succeed in intelligibly doing so. But I know it when I see it, and the motion picture involved in this case is not that." This expression has become one of the most well-known in the history of the Supreme Court, at least among legal scholars. And ironically enough, the "I know it when I see it" has indeed developed into the standard for how justices, courts, determine what's obscene or not. Because in order to even figure out, right, whether a piece of material, artistic expression, a hardcore porn alleged video or not, okay, is indeed obscene under the legal definition and therefore allowed to be regulated, the court must determine whether it meets all three prongs of the Miller test. In order to do that, they have to watch the material. They have to see the material. They have to indeed engage in a "I know it when I see it" type of review. That's why the "I know it when I see it" quote has come up so much and has never died, because yeah, that is kind of the standard. If you want to put it in the most layman's terms, it is kind of the standard. And the reason for that is because all of the attempts to make a more bright line standard than the Miller test have kind of failed, okay, to be consistent across all courts and all jurisdictions. All of the legal tests that we've come up with to determine what's obscene and what isn't are quite vague. And the question of whether a particular film or photo has serious artistic value pursuant to the Miller test definition, okay, of what obscene material is and isn't, is rather obviously in the eye of the beholder. Hence, Justice Potter Stewart's infamous statement that he may not be able to come up with a coherent legal framework to determine what sort of materials should be banned for obscenity, but I know it when I see it. The result was that for much of the 1970s, okay, and think about the 1970s as well with respect to pop culture, with respect to sex and love and intimacy and people engaging in some behaviors that hadn't really been hitting the mainstream as much. The result was that for much of the 1970s, which was a premier decade for porn, if you know, in the pop culture, it just was. The Supreme Court justices on the bench literally had to meet in the basement of the Supreme Court to watch pornographic movies that were the subject of prosecutions in order to make subjective calls about which movies should be protected by the First Amendment. Those movie days, as described by Bob Woodward and Scott Armstrong in The Brethren, were thoroughly humiliating experiences. Justice John Marshall Harlan, for example, was nearly blind during many of these screenings, so one of his law clerks had to describe what was happening on the screen to him, often prompting Harlan to exclaim, quote, "By Jove," or "extraordinary." Oh my God. That blind old bat, like, period. Extraordinary. They pulled that off. Excellent. That is crazy town. By Jove, young man, I must not have heard you correctly. Please begin again. Could you describe that again for me really quick? Wait, did you miss a part? I'm hearing something different than what you're describing. Crazy. In the basement of the Supreme Court too, this was definitely a basement endeavor, I will say. Some things are basement worthy. This was definitely one of them. The reason why this is still relevant today is because of a recent 2025 Supreme Court ruling in Free Speech Coalition versus Paxton. That was a 6-3 decision, and it was talked about in an article on Vox by Ian Millhiser. The opinion held that Texas's law requiring certain commercial websites to verify ages doesn't violate the First Amendment. The issue is that law that they upheld in this case in 2025 is almost identical to the one the court struck down in 2004, but the court did not overrule the earlier decision. Okay, Queen, do what you want. You've been doing randomness for quite a long time, so why not just keep at it? So the point that the author is making in the article about that decision is that the outcome of this 2025 case means that judges will again have to get more involved in making determinations such as whether challenged expression, quote, lacks serious literary, artistic, political, or scientific value. And that, presumably, means more extremely awkward basement Supreme Court movie nights. Those considering Supreme Court clerkships might want to be sure the relevant justice's eyesight is good before taking the job. And with that, we will move on to our second main case of the episode. But I feel like that was a good opener, no? Amazing. Hey guys, we wanted to take a break to thank a sponsor of today's episode, Bear Bells. I am always looking for easy ways to get my protein in that isn't just pounds of chicken, because that wouldn't really work since I don't eat chicken, and that's exactly why I keep Bear Bells protein bars on hand. These protein bars genuinely taste like a candy bar, except each one has 20 grams of protein and no added sugar. The best part is they actually have options of original protein bars, soft protein bars, and of course, vegan protein bars. They are that perfect balance between flavor, texture, and function. You are not getting that chalky, dry protein bar situation flavor, okay? It is soft, it is satisfying, and actually something I look forward to eating. And they have delicious flavors like cookies and cream, chocolate dough, cookies and caramel, and peanut butter. Personally, my favorite flavor is the vegan chocolate brownie. I highly recommend. My boyfriend, who isn't vegan, liked them so much he kept eating them, so he finally got his own. His favorite is the original cookies and caramel. My sister runs half marathons because she rocks, and she was actually the first one to introduce me to these bars. She loves them, and now here we are. How exciting. If you want to try them, you can find them in my massive bucket of a work purse on any day of the week, or you can find Bear Bells protein bars at retailers like Target, Walmart, Vitamin Shoppe, and GNC. Or use code REB, R-E-B REB, for 15% off at bearbells.com. The case of Calcagno versus Springfield involved Rick Springfield, a musician best known for his 1981 hit Jesse's Girl, and also apparently for his Buttocks. He was performing at the 2004 New York State Fair when he allegedly struck a woman with said derriere. She sued about this 2004 concert at the New York State Fair because she alleges that he entered the seating area and interacted with fans, and that during one of these segments, Springfield contacted her with his buttocks and knocked her down, causing significant injuries. Her evidence included a photo of the alleged weapon, which she claims to have taken just before she was knocked unconscious. This lawsuit would culminate in a mistrial in 2013 and a retrial in 2015, which also involved Rick Springfield himself crying and yelling on the stand during his testimony. Several witnesses were called, and everyone involved was dead serious, including this woman's attorney, who wrote a letter to the public begging the public to take them seriously. Let's begin. The lawsuit, Calcagno versus Springfield, was filed in 2007 within the 3-year statute of limitations to file such a lawsuit in relation to assault, battery, negligence, and the like, right? Personal injury claims. Yeah, she did indeed file within the 3-year statute of limitations in New York State. However, imagine having this lawsuit filed against you in 2007. It did not go to trial until 2013. This was a 6-year ordeal, but if you include the mistrial and then retrial, it was an 8-year ordeal. We are going to start with the mistrial and work our way backwards a bit and then jump forward. You'll see why in a moment. I am reading from a legal article reporting on the facts here. In November of 2013, after a series of twists and turns, which we will cover, the judge declared a mistrial in Calcagno versus Springfield just before the case was sent to the jury. The judge had reportedly given both sides 90 days to investigate dramatic new evidence relating to the night that Vicky Calcagno claims Rick Springfield struck her with his buttocks during a 2004 concert. Springfield, though best known for his hit Jesse's Girl and now possibly for his buttocks, was performing at the New York State Fair when the incident allegedly occurred. Springfield's act included segments in which he entered the seating area and interacted with fans. Calcagno alleges that during one of these segments, Springfield contacted her with his buttocks and knocked her down, causing significant injuries. During the trial, his buttocks quickly emerged as the primary weapon accused of causing, quote, serious, disabling, and permanent injuries to the Liverpool woman Vicky Calcagno during the 2004 State Fair concert. A photo reportedly of Springfield's buttocks was shown to the jury during the entertainer's testimony, but when asked whose buttocks were shown in the photo, Springfield responded, quote, possibly mine. Pro tip, never admit that the buttocks shown in a photo are yours except as an absolute last resort. That's not a dead serious tip, but I feel like it's a good rule of thumb. Maybe, maybe not. Springfield did not recognize Calcagno, however, nor did he have any recollection of striking a fan with his buttocks or otherwise, let alone leaving one, quote, disoriented or unconscious for 10 to 30 minutes, as she claims. How does she know she was out for that long? She claims to have, quote, no memory of that time. Could it perhaps have been alcohol-induced? Am I rude for suggesting that? I think we can all say we've had too many beers at a Rick Springfield 2004 State Fair concert, which could have also been the culprit of the no memory situation. No, me neither. But I think a lot of this is something unrelatable. Just trying to connect here. If you can indeed relate to such a hyper-specific event, please let me know. Springfield did not deny the possibility of fan buttock contact, nor could he. According to a review of the same 2004 State Fair concert, Springfield entered the seating area repeatedly that night and, according to one fan, quote, was really connecting with everybody. Whether that connection, including his cheeks, being used to connect quite literally with fans, is again disputed. However, the fans seem to have been doing the most cheeks-related connections. Quote, throughout the concert, the review notes, Springfield let his fans grab his buttocks while he traversed the seating area, singing and playing his guitar amid the crowd. Evidence of recklessness, perhaps? Because, hello, Rick Springfield, you are running aimless through your crowd, swinging your hips in such a manner that anyone could have very easily been in the crosshairs of your derriere. I am pretending like I am the counsel in this case here because practice is fun, right, for a situation such as this that I hope to never find myself in. But Calcagno had unfortunately no witnesses to back up her claim that there was any contact in her specific case, probably due to the fact that this happened in 2004. She did file her lawsuit within the 3-year statute of limitations, but yeah, in 2013, I don't think a lot of people are going to recall a lady getting swung on by ass in 2004 at a concert they probably don't remember a whole lot of, but who am I? In fact, she conceded she did not leave the concert or seek medical attention at that time. I mean, I paid money for the tickets, right, Vicky? I get you, girl. You're not leaving except in a body bag. Fair enough. But she did offer medical records dated 2 days later, which stated she had head and neck pain, muscle spasms, jaw pain, shooting pains in her left eye and right foot, insomnia, and sensitivity to bright light, all of which she now attributes to a celebrity buttocks-induced fall. Things started to get really weird, if that wasn't really weird enough, early in November 2013, when an unidentified woman called the judge during the trial to say she wanted to testify against the plaintiff. Springfield's lawyers, though, possibly feeling they did not need any help with this one, declined to call her as a witness. But later that day, Calcagno's attorney reportedly saw a comment posted on news site CNYCentral.com that corroborated his client's account. The report states that he posted his own comment asking that person to contact him, and by Wednesday morning, she and her family had done so. I mean, what the fuck? I'm on the edge of my seat, 2 cheeks down, and safely away from people's faces. I don't know about y'all. Hi again, everyone. Rather than fill this ad spot with a read from a paying sponsor, I am donating the spot to small businesses and mutual aid efforts in Minneapolis that benefit their community of immigrants, protesters, and activists. Today, we are spotlighting the Immigrant Law Center of Minnesota. They are a nonprofit organization that provides free immigration legal representation to low-income immigrants and refugees in Minnesota and North Dakota. They also work to educate the community about immigration matters and advocate for public policies which respect the universal human rights of immigrants. Every dollar donated goes to supporting their mission of providing the highest quality legal and educational services to help low-income immigrants. Please join me in donating by visiting their website, www.ilcm.org/donate. This link can also be found in the description of this episode. You can also donate through other mediums, which you can find more information on by clicking on the Ways to Give tab on their website. Again, please check out their website, www.ilcm.org/donate. Hi again, everyone. Rather than fill this ad spot with another read from a paying sponsor, I am donating this spot to a different small business and mutual aid effort in Minneapolis that benefits immigrants, protesters, and activists. Today, we are spotlighting the Pimento Relief Services, started by the Pimento Jamaican Kitchen. They work closely with activists, community organizers, nonprofit agencies, the business community, local and federal government, funders, investors, academics, dreamers, and visionaries from all backgrounds to build an inclusive society where everyone can prosper together. Not only do they support people in their own communities, but they also raise money and gather donation items to support others as well. In this current crisis, they are gathering donations for their Immigrant and Restaurant Frontline Relief Fund. Donations will help provide emergency relief for immigrant workers and families, support restaurants experiencing sudden labor and revenue loss, and sustain frontline economic liberation efforts led by and for impacted communities. Please join me in donating to this effort by visiting their website, www.givemn.org/organization/pimento-foundation. This link can also be found in the description of this episode. That is www.givemn.org/organization/pimento-foundation. I personally couldn't find any of the comments specifically on that website. Most of the comments, if you look back to 2013 on these blogs and forums and comments permitted on certain news sites, 99% of these commenters are in favor of Springfield. They are. They think that this is redonkulous, which I'm not going to pass judgment. Some people, right, do deserve to sue. Don't even get me started on the McDonald's hot coffee case. That woman absolutely deserved every penny and more, if not double, what she got. She literally suffered horrific burns, and that coffee was way too goddamn hot, and McDonald's knew it. I digress. Maybe I'll do an ep on it later. But regardless of whose camp you are sitting your cheeks next to, all right, in this dispute debacle, what's not really clear to me is why this last minute nonsense was allowed to affect a trial that was literally almost over. It seems like the morning that deliberations are set to begin is a little late to add anyone to the witness list, no matter how you found them. But I guess when the stakes here are just so high, truth is all that matters. Rock on. So the judge basically said stop the presses. He would allow the witnesses to be called and gave Springfield's attorneys 24 hours to prepare. They then objected, understandably, that this was not enough time and asked for a mistrial. The judge agreed. Vicky claims that the incident left her disoriented or unconscious for at least 10 minutes. But her lawyer told jurors that it was probably less. He was like, not too much, girl. You are hitting it a little too hard here. Let's be a little bit more realistic, which is so funny. Regardless, she claims that this incident caused her serious and lasting injuries. Again, weapon used, 2 cheeks belonging to Rick Springfield. The photo of Springfield's buttocks was long sought by the media throughout this lawsuit and during the trial. And for whatever reason, it took a really long time for it to be released. So when it was everywhere. This is the photo. This is the picture. And to be clear, it's the picture that the plaintiff, Vicky, claims she took just before impact by the alleged Springfield derriere pictured here. The fan located in the background is, of course, blacked out to maintain anonymity during this crime, right? They are simply a bystander, innocent that they were. As I said during his testimony right before the mistrial, Springfield did say that it might be his, right? Maybe, maybe not, okay? But right after the photo was released, the mistrial was called, and a retrial is literally in the works. So everyone's freaking out a bit in the media, on forums, saying mostly 99% of these comments, as I said, are like, why is this woman doing this? And we are Team Springfield, okay? Lending our support to the cheeks in question. The plaintiff's lawyer, Vicky's lawyer, wrote a letter to the Syracuse Post-Standard, a news site, responding to comments posted on the paper's website, comments that were overwhelmingly anti his client. Quote, "My intention is not to persuade you to change your initial impressions, as I understand that first impressions are made only once," he wrote. "Rather, my intention is to present you with the facts in hopes of demonstrating that those of you who rushed to judgment without knowing the facts may have done so prematurely." If he doesn't want to change people's initial impressions because he doesn't think that he can, why are you writing this letter then? Why are you writing this letter, period? This is the letter, because of course we need to hear more. I am locked in, baby. I want to get to the bottom of this, pun intended. Again, this is written by Kenneth B. Goldblatt, the attorney for Vicky Calgagno. Quote, "As many of you know, as part of his act, Mr. Springfield ventures out into the audience where he performs a few songs. However, before doing so, as a means of ensuring both his safety and that of the members of the audience, Mr. Springfield goes into the seating area to, quote, scope it out in order to test the stability of the seating. When he thinks it is unsafe to do so, including at times when the seating is unstable or is wet, he will refrain from going into the audience because, fully expecting to be jostled and pushed from all sides, he understands that unsecured seating and or wet conditions will make it difficult for him to maintain his balance. On August 28, 2004, Miss Calcagno, like many others, attended the Rick Springfield concert. The afternoon show, which was scheduled for 4 p.m., was rained out. The next performance was at 8 p.m., and during that show, as planned, Mr. Springfield ventured into the audience, walking onto chairs as he performed. At some point, he reached the area where Miss Calcagno was standing, with one foot on her chair and the other positioned on a plastic railing that separated different seating areas. Mr. Springfield, after being jostled by the audience, lost his balance, causing his butt, he says the word butt, to strike Miss Calcagno, knocking her down and causing her head to hit the hard ground. Some castigated Miss Calcagno for having the temerity to sue Mr. Springfield in what was labeled an obvious attempt by a welfare woman seeking money. To begin with, Vicky Calcagno is not on welfare. Rather, she is an educated woman, the mother of a 13-year-old girl, and prior to 2004, was consistently employed in the finance industry. While Mr. Springfield is viewed by many as a, quote, rock star, having had the opportunity to meet and observe him, I can say that underneath his persona, he is just a regular person, a very nice gentleman who, like all of us, is capable of a lapse in judgment. What then was this lapse in judgment? Contrary to his regular protocol, Mr. Springfield admitted that prior to the show, neither he nor anyone on his behalf tested the seating or the railing to ensure their stability. In fact, the plastic railing was not only flimsy, but also wet. Due to the prior rain and overall dampness of the night, conditions which Mr. Springfield acknowledged could potentially make it difficult for him to maintain his balance while being jostled. Stated differently, Mr. Springfield knowingly ventured into the audience under conditions he knew posed a potential threat of harm. Some castigated Miss Calcagno for making up the whole story. It sounds like he just learned the word castigated and wants to say it about 1 million times. I think once is enough in a letter such as this. I, of course, appreciate the use of a wide vocabulary, different words, but I think at this point we need to probably change it up. Castigated it's too much, right? Too many times I've heard it. Some castigated Miss Calcagno for making up the whole story, especially because she did not report the incident at the time that it happened. However, thanks to your posts, ladies and gentlemen, an eyewitness surfaced who not only confirmed that Miss Calcagno was not lying, but also disclosed that she too was knocked down by Mr. Springfield. Of note, she too did not report the incident, and she neither knew Miss Calcagno nor had ever spoken to her. Others castigated. Again, pick a new verb. It's too much. We get it. You're a lawyer. You know big words. This isn't even a big word. It's just not the type of repetitiveness that drills the point home to someone. It just sounds like you're being condescending. Certain words are condescending. That one kind of is. Others castigated Miss Calcagno for remaining at the concert and not immediately obtaining medical care despite being, quote, knocked out. While Miss Calcagno did testify that she was unconscious, as is often the case with those who sustain concussion, an injury for which she received a medical diagnosis and to date still receives treatment, Miss Calcagno's perception of being unconscious was more likely disorientation. So he's like, all right, don't really listen to her that much. A state that often feels longer than it really is, resolves without further immediate symptoms, and which is the accepted medical definition of a, quote, concussion. What was not reported in the media was that Miss Calcagno experienced symptoms the following day, which was a Sunday, and sought medical attention on Monday. She also notified officials at the state fair about the accident via email, seeking a way to contact Mr. Springfield's representatives. After repeated unsuccessful attempts to elicit a response from officials, Miss Calcagno retained the services of a lawyer. Me. Do with that what you will. Okay, got it. But the plaintiff isn't claiming he went out there with a hunk of plutonium, just his buttocks and maybe a guitar. And the lawyer's explanation still seems a little thin when it comes to explaining the plaintiff's injury. Springfield allegedly fell onto plaintiff or struck her with his butt, knocking her down and causing her to hit her head hard enough to sustain a concussion. That's certainly possible, but it is odd that plaintiff showed no signs of injury at the time. Originally, she claimed she was knocked unconscious, like I said, but now they seem to be backtracking and saying it was disorientation. These seem like two entirely different things. Pick one. Obviously, as we know from watching NFL football games, any type of football game, just because you sustain a concussion doesn't mean you knocked out. You can be disoriented, right? Show signs of a concussion that doesn't include you being completely unconscious, all right? That's why you have to go through concussion protocol. But yeah, I mean, let's really certainly save that chat for trial, my guy. Maybe that's just me. Hi again, everyone. Rather than fill this ad spot with a read from a paying sponsor, I am donating another spot to a small business and mutual aid effort in Minneapolis that benefits immigrants, protesters, and activists. Today, we are spotlighting Neighborhood House MN. They are dedicated to making sure everyone who calls St. Paul, Minnesota home can live and thrive there. Primarily, they serve low-income immigrant, refugee, and underrepresented communities. They work with the entire family to ensure their basic needs are met, as well as ensuring access to free education programs so they can live safe, stable, and rewarding lives. They are also partnering with local small businesses in Minneapolis, including a local restaurant called El Burrito Mercado. El Burrito Mercado is a family-owned small business accepting online gift card donations, which will be directly used to feed families impacted by detentions. Please join me and donating funds or basic need items directly to Neighborhood House MN. If you are a resident of Minnesota, you can also join their volunteer list. You can find more information on this and donate on their website, neighborhoodhousemn.org/community-crisis-response. Or think about donating a gift card with their partner El Burrito Mercado at www.elburritomercado.com. These links can also be found in the description of this episode. That is neighborhoodhousemn.org/community-crisis-response or www.elburritomercado.com. But again, we have a mistrial and a new trial to contend with. I am certainly waiting with bated breath to hear what happens. 1 entire year later, November 9th, 2014, this article was posted. You will be pleased to know that the plaintiff who accuses Rick Springfield of assaulting her with his butt has not given up despite an earlier mistrial. According to the Syracuse Post-Standard, lawyers for Springfield and plaintiff Vicky Calcagno were back in court a few months ago to discuss future proceedings, and the report says that a retrial is still the plan, but will happen in January 2015 at the earliest. That retrial began in January 2015, and Rick Springfield yelled and cried while on the witness stand testifying in that retrial. After the plaintiff's lawyer, Kenneth Goldblatt, called Springfield to the stand, Springfield accused Goldblatt of being, quote, very aggressive with his questions and later raised his voice and pointed at Goldblatt. Springfield said he felt like he was being called a liar. Springfield was emotional again when his lawyer, John Pfeiffer, asked him about going out into the audience to be closer to his fans. Springfield choked up and was given a tissue for his tears. I get emotional sometimes, Springfield said. Springfield answered questions for more than 90 minutes, often smiling and occasionally laughing. Goldblatt asked Springfield if he was a heartthrob, and Springfield agreed with a smile. Goldblatt also asked Springfield if he's ever been grabbed by female fans. Springfield said it's common for women at his concerts to, quote, grab my butt if they're feeling a little saucy. As you guys know, Justice Anthony Paris declared a mistrial in 2013 when a new witness came forward. That witness was finally named in the retrial. Her name is Penny Ann Nolan of Port Byron, who contacted Goldblatt during the trial to tell him that she was also knocked down by Springfield's butt during the 2004 concert. Nolan, who was not allowed to be photographed by the media in the courtroom, testified. She said she was at the show, and when Springfield entered the crowd, she left her seat to get closer to take photos. She ended up directly in the line of sight behind Springfield as he played his guitar and sang. Nolan testified that Springfield had one foot on the back of a metal bench and the other foot on a white fence. Nolan said Springfield fell backwards and his butt hit her forehead and she was knocked to her knees. I did not see anyone else get knocked down, she said. Nolan said she didn't see Calcagno get knocked down or laying on the ground, and she had never met Calcagno, and he, quote, I was helped up by a woman standing next to me, she said. When Nolan stood up, Springfield was making his way back to the stage, she testified. And in a not-so-shocking twist, Ronald Greinel, Springfield's tour manager, also testified. He actually was called to the stand first. Greinel said he first met Calcagno, the plaintiff in this case, in 2008 when he was giving a deposition for the 2007 lawsuit. At the deposition, which was held at Turning Stone Resort and Casino in Verona, Greinel said Calcagno asked for tickets to Springfield's show at the resort. Springfield also testified that Calcagno asked for concert tickets. Girl, honey, he doesn't want you to go anymore. I'm so sorry. Never meet your idols, I guess, right? My God. What was the outcome? We finally found out January 16th, 2015. After an hour of deliberation in the trial of singer and actor Rick Springfield, a jury found in favor of the defendant, Rick Springfield. Specifically, the jury deliberated for 61 minutes. During that time, Calcagno left the room on a stretcher and was taken away by ambulance. Her attorney said she suffers from seizures. Springfield expressed relief after the verdict was announced. Quote, I'm incredibly relieved. Results like this are positive for everybody. There's too many lawsuits in this country. Vicky Calcagno's case faced several shortcomings, which Springfield's attorney pointed out in his closing argument. First, she had no witnesses to corroborate her story that Springfield fell on her. Two, she had no proof, video or otherwise, of the incident. A video taken by superfan Michelle Tellier showed Springfield stumbling at one point during the concert, but did not show the alleged fall on Vicky. Third, Calcagno's credibility came under question during the trial. Pfeiffer disclosed that she asked Springfield for concert tickets during a deposition in 2008 and also in 2010. When she emailed the NYS Fair about the incident, she didn't mention specific injury, but asked for Springfield's contact information. She also attended a Cyndi Lauper concert a week after the Springfield concert in 2004. I'm just going to leave you with that. My rebuttal for today's episode is if you ever go blind, make sure you have someone available to dictate what is exactly happening in dirty movies to you personally, including extremely detailed descriptions, hopefully as detailed as possible so you can really get the full experience, right? Because just because your eyesight is poor doesn't mean your taste in movies needs to get any better. I would also say watch where you are throwing your butt around. Stay safe, everyone. Thank you for listening. I will see you guys next time. Love you for always and forever. Bye.